and gentlemen, a teenager, 17-year-old, few months short of turning 18, is accused of drunken driving, speeding his dad's Porsche, killing 2 young people in May. The High Court today has ordered for his immediate release from the observation home, saying his continuation there is quote-unquote illegal. Why so? How did he reach there though? Help me to remind you. He was released on bail and then brought back to the observation home for questioning, even as the bail order was amended, not cancelled. That's the important peg that literally changes the entire case now, as we are seeing with what's coming out of the High Court. Amid public furore after the easy, fast bail and the conditions involved. So remember this, the bail order was amended, not cancelled. This being the big clause that's coming up now. And a series of allegations of massive lapses in a network that attempted to destroy evidence. The prosecution claimed the order was amended after the facts came to light of the juvenile being under the influence of alcohol, something they claimed was not presented to them earlier. It is unfortunate our own people didn't present facts before the juvenile board on May 19. He was shown fit and not under the influence of alcohol. The circumstances presented that day led to pass the order, which was eventually passed, and that was the bail order. This is what the prosecution claimed before the court, suggesting bail should have never been granted. The teen accused since then has been at the observation home for around 25 days since the bail was granted and then amended, not cancelled. I'm repeating this again because this is key in this case. Now, what has the court said today, the High Court? What has it gone ahead and said? The child in conflict of law is under 18. His age needs to be considered. Age not considered due to the immediate reaction, the knee-jerk reaction and public outcry. He must be treated as a child despite seriousness of the crime. 2 people have lost their lives. There was trauma, but the child was also in trauma. It was almost a month ago on May 19th that the teen accused in now the infamous Pune Porsche case was granted bail, instantly creating a massive furore and public outcry. The teen accused, technically referred to as a child in conflict with law under Juvenile Justice Act, while being granted bail, was ordered to write an essay of 300 words on the topic of road accidents and the solutions. The board also directed the youth to be referred to an alcohol de-addiction center for counseling, among others. Remember the lapses that subsequently came to light, failing to inform the control room on the night of mishap, served pizzas and burgers to juvenile in custody, the preferential treatment, the allegations around that, 8-hour delay in collecting blood samples of accused, a weak FIR that was initially filed and allowed the JJB to grant bail, failed to challenge JJB's bail order in Bombay High Court, which literally means the bail, the initial bail was not cancelled. Remember, the minor's parents, as well as his grandfather, all influential people, real estate barons, were arrested in various cases registered against them in connection with the accident, including destroying evidence, coercing the family driver to allegedly take the blame that he was the one driving the car instead of the minor. All of this happened even as the police, the Pune police, claimed that they have moved for the accused teenager in this particular case to be tried as an adult. A clause that was allowed for, as I mentioned earlier, after the Nirbhaya case. We'll get into that as well, but first, let's listen in to victim Ashwini Koshta's mother, what she had to say regarding what unfolded in the court today.
मुझे पूरा विश्वास है अपनी न्याय व्यवस्था में. उनने भी कुछ सोच के मतलब ये फैसला किया होगा। और आगे बस मेरी एक रिक्वेस्ट है न्याय महोदय से कि एक माँ का दर्द समझे। मैंने अपने एक बेटी को खोया है, तो उस स्थिति में मतलब क्या वजह है, क्या है, उस हिसाब से मतलब उसको सज़ा दे। तो बोलना चाहिए कि इस केस में सही न्याय हो तो जनता भी अपनी न्याय व्यवस्था पे भरोसा कर सके। और मुझे पूरा विश्वास है कि मुझे ज़रूर न्याय मिलेगा, क्योंकि महाराष्ट्र सरकार ने भी हमें पूरा विश्वास दिलाया है कि न्याय होगा।
All right, beyond all the noise, the clutter, we promise you one thing: to bring you all aspects of the story to try and understand what's playing out. I'm opening this up to our panelists at this point. I'm being joined by Abha Singh, who's a lawyer, Nirmal Kaur, who's a former IPS officer, Naveen Chomal, who's a lawyer, Shel Tagi, who's a legal aid counsel at the Juvenile Justice Board in Delhi. Thank you very much, all four of you, for joining us. Ms. Abha Singh, to you first. What do you really make out of what's happened in the court today? The court had some very strong words for the Juvenile Justice Board, including there seemed to be knee-jerk reactions to what seemed to have been the outcry. Now, what does one really make out of the judicial system?
You know, there is a Juvenile Justice Act, and that act emphasizes more on reformation. It talks of not jail for a juvenile, because and they don't even call them offenders. They call them children in conflict with law if they are under 18. So in this case, this child was
Correct.
below 18. In the first place, if you are not sending him to an observation home, you send him to give him bail. So definitely it is knee-jerk. And then under public pressure, if under public pressure you are going to take him back in jail, the law does not work on that. What law is, it has to be followed in the true spirit. And in this case, I think Bombay High Court was right in giving him bail.
So if you're saying the Bombay High Court was right giving in bail, now, you know, help us to understand what is unfolding right now, because you have a Juvenile Justice Board that first gave him bail, then amended the bail, then sent him to a correction home or an observation home, as it is called. So are we then saying that the Juvenile Justice Board completely lost the track?
Absolutely. In fact, what we read subsequently was that the judicial member of the Juvenile Justice Board was not there. Only the NGO members were there, because the board consists of 3 people, a judicial authority and NGO members. So at that time, but whatever, once you have let the child go, and then only under public pressure. Courts are not supposed to work under public pressure. You have to follow the law of the land. Also, the big issue was that his when he was left, it was not cancelled. Without cancelling, you just called him back again, and that gave the defense lawyers a very big feel that the goof-ups done by the police led to the bail today in Bombay High Court. I think the fault lied on the authorities. Had they been more meticulous, things would have been different. And also, if you see today, the mother, the grandfather, they're all in jail because they have violated the law in the true sense. For them, there are no correctional homes. For them, we don't talk of that reformation. So they are in jail, but this child, being less than 18, had to be protected under the law, and that is what the Bombay High Court did today.
Shel Tagi, if I can come to you. Shel Tagi, do you see this as a classic textbook case of what must not be done? Has the Juvenile Justice Board failed to do what they were meant to, what they were instituted for? Have they failed in ensuring, delivering justice, in even justice, whether it be to the minor or to the victims? Did they completely err?
If I'm talking about the JJ board is actually consisting or formed only for the rehabilitation of the child, of the juvenile, or basically it is formed in the best interest of the child. Whatever they have to do should be in the best interest of the child. And if definitely they are not doing anything in the best interest of the child, it should be stated that definitely they are acting arbitrarily, they are not doing their work properly, or they are definitely not going according to the law. But if I'm stating they, because of that, the pressure of the public, what they did is they have not cancelled the bail. They just amended the bail order, which is not good.
So
That's why.
Shelly ma'am, help us to understand legally, Juvenile Justice Board, what must it do? अब अगर वो कह रहे हैं कि उन्होंने bail दे दिया, if they gave bail to this particular accused teenager, because they were not given the facts as it was supposed to be given, they were not told that he was under the influence of the alcohol. That's what the Juvenile Justice Board has claimed. They were told that he was fit. So if this is the case, and if he was granted bail, and if that needs to be cancelled, so what should be the protocol? What was not followed here? Will you help us understand that? क्या follow नहीं किया गया?
Basically, अगर मैं कहूँ the very first starting जब इन्होंने bail दिया था, they have granted the bail. At that time, the law was followed, because outrightly अगर मैं कहूँ whatever be the offence, it should consist of mens rea. Intention should be there. However, in these kinds of cases, it is just an unfortunate accident. जो उसने भी नहीं सोचा था कि whatever is going to be happen in the next moment, जिसकी वजह से ये सारा जो है एक्सीडेंट हुआ, बिकॉज ऑफ दैट रीजन. तो फर्स्ट ऑफ ऑल अगर मैं कहूँ कि इंटेंशन था नहीं, अनफॉर्चुनेट था, लॉ जो है वो ये कहता है कि वेदर इट इज हीनियसनेस और सीरियसनेस, डिस्पाइट ऑफ दैट द बेल शुड बी ग्रांटेड टू द जुवेनाइल. बट बिकॉज ऑफ द रीजन कि देयर इज अ पब्लिक प्रेशर, समवेयर द थ्रेटनिंग, देयर वाज अ थ्रेट टू द लाइफ ऑफ द जुवेनाइल, might be अगर उसको बाहर निकाला जाता है, then in that situation might be the board should be realizing कि whatever they had did means जो उन्होंने उसको बेल ग्रांट किया है, तो शायद वो बेल जो है वो उन्होंने गलत ग्रांट किया है. That's why they, without cancellation, they amend the order. However, they don't have the power to amend that order. Because of that reason, High Court
if they don't have the power to amend the order, what should they do? क्या करना चाहिए? What should they have done? I'm asking you this question because we are lay persons. We are not Juvenile Justice Board. You are part of the Juvenile Justice Board, of course, in Delhi. So definitely, if you are saying they don't have the power to amend, what is the power? What should they have done?
They have done, actually उनको जो है bail amend ही नहीं करना चाहिए था. जो bail उन्होंने grant कर दी, that should be okay and fine because of law. Law says this thing. So here अगर उन्होंने कर भी दिया, then accordingly he should be released. And psychologist की reports वो कर सकते हैं, counseling they can provide them the counseling, और counseling के लिए जो है जरूरी नहीं है कि उसको अंदर ही custody में ही रखना चाहिए, observation home में ही रखना चाहिए. So counseling and psychologist report should be sufficient in this matter.
Okay. Naveen Chomal, if I can come to you, sir, is this such an ironical case, if I may say so, because you have two people who have died, who have been killed, if I may say that word. I mean, the intention still has to be proved in the law whatsoever, but nonetheless, two people have died in that case of the road accident where the teen accused was in an inebriated state and was speeding in his Porsche. That is what the police have said on record. Now, look at what's unfolded. A juvenile has had to stay in an observation home for 20 to 25 days despite being granted bail. The Juvenile Justice Board would definitely have known that they did not have the right to amend it. How did they go ahead and amend it? How can they be so blatantly violating it? We have a Juvenile Justice Board member here who's speaking to us, of course, of another Juvenile Justice Board, but she explained the powers. So one is the board that was meant to protect the interest or protect the individual, the teenager in this particular case itself seems to have failed. What about delivering justice to somebody like the families who are now saying we just believe the legal system? Isn't this case falling apart from all forms, considering there were massive lapses and pushes and pulls used from the family of this accused teenager as well?
Exactly, Sneha ji. I am on the same page. See, what they have done is given the emphasis on Section 12 of the Juvenile Justice Act, which provides that any child who is in conflict with the law, he should not be detained and tried to be set released. Fine. But juxtaposition to that, there is also the provision under section 15 and 18 of the same act, which, as you know very well, which gives the power to the board to judge. Since he is about the age of 16 years, he is 17 years, 8 months. So since he is of that particular age, they have the power to judge his mental capacity and criminality, also the mens rea part of it, and whether he is able to understand the consequences of his act. So then in that case, they could have come to the conclusion that exercising the power under section 15, he should have been directed to be tried as an adult, as what section 18 clause 3 provides then. So that should have been done. So rather than focusing simply on section 12, they ought to have taken the course of section 15 also. It would have taken much long time for the JJB officials to do it, members to do it. So here, what has happened, unfortunately in this case, they exercise the power under section 12 and so very leniently, because as we say, justice should also be seen to be done. So they let him also leniently, and then again they change their order, which they don't have the power to amend the order. So the High Court had a limited question before it, whether the action done by the JJB members was correct or not. So High Court definitely had to rule out that this particular possibility is not correct, and the action taken by the JJB in again sending back to the correction center was not correct. Let him be released and put in the custody of his aunt. But now still the application is pending before the board to consider whether to treat him as an adult or not. So that should be expedited. That should not be taken much time, because there are other circumstances and facts on record that he was drunk. Then there is a record that he was sitting in a bar.
You know, Mr. Naveen Chomal, that itself is a question. If a Juvenile Justice Board in Pune has already botched up, if they've already got their basics wrong, and if there is a High Court which is saying that you have acted under pressure, this seems to be knee-jerk reaction, you've not given, you know, what you're meant to do to this particular teenage accused. If there's a High Court already telling this to the Juvenile Justice Board, how can anybody expect the Juvenile Justice Board to be acting in the best interest of justice any further?
Definitely. In this case, at least people's eyebrows are raised. People are very unhappy about the manner in which this particular case has been handled, and even the High Court's order, though they have adhered to the law, but they ought to have also considered section 15 and could have, because High Court doesn't have the power only to confine to the prayers in the petition, they could have gone a step ahead and directed the board to consider the application under section 15 as early as possible. Okay. And if is found to be liable to be tried as an adult, that should be done as early as possible. So that the High Court has fallen short of.
Okay. Okay, Ms. Nirmal Kaur, if I can come to you. At the beginning of the show, Ms. Abha Singh had gone ahead and said that the cops have poorly goofed up in this case. We had a top cop in Pune come up and say that we are now certain about the intent. He was very much aware of the consequences of his action, that he was drunk, he was inebriated, he had broken the law. There was attempts to get the driver who was riding by the side of this particular teenager who was to take the confession for this case. My point being, from the police, the big lapses that have emerged to what has unfolded before the Juvenile Justice Board, isn't this a completely crumbling system?
I basically feel, you know, that the whole thing sounds like a travesty to many people who would hear the facts of this case. And the bail order, maybe as the JJB member said here, that it cannot be amended, but it surely could have been cancelled. Why was it not cancelled in the first place? Of course, the cops have washed up. Initially, at least, you know, there's even a thing that the samples were switched at the hospital. The blood samples were switched. I read in the papers, in the media somewhere, and then doctors were arrested. So right from the beginning, the whole ecosystem has been trying to manage the case, to manage it to the benefit, for the benefit of this teenager. And he's just about a few months short of 18. And we've been hearing that, after Nirbhaya, there's this law and they are going to apply it, saying that he who is going to be tried as an adult. So all this turned out to be, that possibility is still there. But what I mean is that two young lives have been lost. Two young lives have been lost because this fellow was drunk, this so-called teenager within inverted commas. He was drunk and he was drinking from bar to bar, moving from bar to bar, and he came from a very rich family. He had a car, a very fancy car, which was not even registered. Maybe it was registered, but the registration number was not there.
But is this also, while the JJB Act, the JJB board surely should have cancelled it, and we'll try and understand why it did not. With your years of experience, wouldn't you also say that the police have completely botched it up as well? There were suspensions in the police
initially
that happened.
Because it was not even reported in the control room, on the control room. It was not reported in the control room that such a big incident has happened where two young people have lost their lives. It is a very serious case. And I think initially right till date, the whole ecosystem is trying to favor the teenager, the offender in this case. And in this case, the father can be, the owner of the car can be arrested right away, even without even if whether somebody is killed or not. If somebody who's not entitled to drive is driving, less than 18 is driving, the father can be immediately arrested. And the father, I think, also got the bail a few days ago. He got bail and...
right. In fact, you're making such important points, and it's absolutely unfortunate in this particular case, whether it be Abha Singh, whether it be Nirmal Kaur, Naveen Chomal or Shel Tagi, all of them just seem to be highlighting one point, and that's what the High Court has mentioned very categorically today, about how there seem to have been knee-jerk reactions and an immediate response to the outcry, public outcry. But Abha Singh, if I can ask you the last question on this show, if this is what a court has to say about a juvenile justice board, what system can the citizens really be looking at? Because this case is only beginning. It's nowhere near its conclusion. A lot rests on the Juvenile Justice Board, which already has failed, miserably failed if you go by the words of the Bombay High Court.
If you see the appointments of juvenile justice boards, you say there'll be members from the NGO. We know what type of people are put in Women National Commission for Women or these juvenile justice boards. I would definitely say, when you say knowledge of law is a must, please see to it that the people you appoint, they're basically political appointees or people who have contacts. So merit should be the thing. And people who know the law in the real sense, put some strict qualification. Just not any NGO you have worked in, or you know a politician, you become a member of JJB. So that is one thing which I feel is very important. And second is that if it is a case of drunken driving, police power should be made very fixed. You cannot give bail. You have to put only non-bailable sections. You have to ensure that sections are such that bail cannot be granted. Because police has the discretion, they put rash and negligent driving and give bail. They get a lot of money. So here,
unfortunately, ma'am, in this particular case, it took 8 hours for even the blood samples to be collected. That's the irony.
True.
The arrest happened late into the night.
Yes, you had an NCP MLA sitting
8 hours later eventually that the blood samples were
compromising. Yes, and also the samples are changed because you had an NCP MLA sitting in the police station influencing the IO. The CRPC says that the IO cannot be compromised. So you compromise the police directly by getting an NCP MLA sitting. What has happened to him? What action has been taken against him?
All right. Even as we try and decode this case, the truth remains. A very important verdict from the court. The court has clearly highlighted how there was injustice for the teenaged accused in this particular case. No one thought that was the case. Why am I saying that? Because this case has fallen apart on technical grounds. The JJB has failed to do what it was meant to do. The police has failed to do what was meant to do. Where does the buck stop? Who's going to be responsible? There's a whole long journey ahead, but what can ensure that what unfolds now is going to be just, considering the rot that has already been exposed? Abha Singh, Nirmal Kaur, Naveen Chomal and Shel Tagi, thank you very much for joining us. Unfortunately, we don't have any conclusive remark to make. The sad and the irony really remains in the fact that how unfortunate the developments have been.